Sure.
Or Florida. Okay, so we have basically on the docket today, as you all know, two cases that are pretty much the same. We have this one and we have the one that follows it, Venice HMA versus Sarasota County. Very similar cases, except for the second case has got two issues that aren't in the first case. So we discussed among ourselves how we're going to handle this, and we're just going to treat these as two totally separate cases, give everybody their full 20 minutes, and we'll, because this is a big case, important case, complicated case, and hearing some things twice isn't going to be a bad thing, okay? So I just want you all to know that. So would you like to reserve 5 minutes?
I would, thank you, Your Honor.
We're ready whenever you are.
Thank you. May it please the court, I'm Steve Athenia, and along with my partner Gabe Warren, we represent Sarasota Doctors Hospital and Englewood Community Hospital. We're here because the trial court adopted Sarasota County's position that its sovereignty allows it to ignore a constitutionally valid payment obligation in the Special Act. The trial court disregarded that the Florida Supreme Court upheld as constitutionally valid the very reimbursement provisions in the Special Act that are...
Anywhere in that opinion, did they mention sovereign immunity? And I know you all briefed this issue, so I'm giving you a softball
Sure.
question.
No, Your Honor, but the finding that the county's charter powers didn't excuse the payment obligation is a very parallel argument to the argument that we're making here. The Supreme Court found that payment obligation was mandatory, and that's what we have here, a mandatory obligation on the county where sovereign immunity is completely inapplicable. And so if that payment obligation is to mean anything, which
so
is...
your arguments it's a ministerial act? You're raising
The payment is a ministerial, the payment itself, the function of paying is a ministerial act because the Supreme Court upheld the constitutionality of the Special Act.
There's no question they did that. But the real question is, did they address sovereign immunity or did they need to? Is there is this law the case and this is issue preclusion?
Absolutely. I think that it is because not only here, but in Sandegren. In Sandegren, the court found that a valid payment, again, Sarasota County tried to avoid their obligations under the Baker Act to pay for health care. A very similar health care initiative. It was a general law.
Based on a general act.
It was, but that's a distinction without meaning.
I'm getting confused here. So you're making a law of the case argument, but now you're bringing in Sandegren. I mean,
Well, it
there's two
supports
separate
it.
arguments, right? One is that the prior, if you look at this case, the law of the case, as to sovereign immunity, as a sovereign immunity, and then you're also making a parallel argument about a case that, by analogy, makes your point that sovereign immunity doesn't apply, right? Let's keep these things straight.
Yes, sir, but I would say that the Supreme Court, in upholding the statute, Sandegren is supporting what the Supreme Court's already done in this case. The Supreme Court in our case had before it the issue of whether Sarasota County had a mandatory payment obligation on it. The court found that it did. Here, the county and the trial court don't even want to get to the issue of whether sovereign immunity is applicable. And it's a distraction. They're suggesting, waiver's the question. But you don't even get to waiver without determining whether sovereign immunity is applicable. And here, clearly, sovereign immunity is not applicable. I couldn't find a case, there is no case that the county has cited where sovereign immunity has been held applicable where you've got a valid special law. And that's the situation we have here. I mean, the court's opinion will have no meaning, and the legislature's action would have no meaning if this court finds the county's position persuasive. I mean,
Let me ask you this, okay, so there's no meaning, but if, to play the devil's advocate here, I mean, there's no private right of action because of sovereign immunity, but that doesn't mean that doesn't necessarily, the conclusion has no meaning.
Well,
I mean, if a tree falls in the woods and no one's there to hear it physically fall, I don't know, but I mean, if there's no one to sue to enforce the obligation of the Special Act, does it have enforcement effect? I don't know. Is the fact that sovereign immunity might foreclose private action to enforce the duties of Sarasota County under the Special Act, Does it mean that it renders the act of no force effect? I mean, how, because other ways in which it could be enforced?
I don't know how else it could be enforced, Your Honor. I mean, we have a situation here where the court spoke, you know, the county raised the issue under its charter powers. They're not compelled to pay for the indigent care. They were, as a county, sovereign. But we have to remember that sovereignty flows from the Constitution. And what the legislature is the superior body here. The legislature has the power to dissolve counties if it chooses to do so. The legislature spoken in a constitutionally valid mandate here, saying that the very issue at the heart of the case was the payment provision in the special act. The county had no problem with any other part of the special act.
So section 125.01 of the Florida statutes, powers and duties of counties. Section 1 reads, the legislative and governing body of a county shall have the power to carry on county government to the extent not inconsistent with general or special law.
Yes, sir.
Does that impact this case in some way?
Well, certainly, you know, it is inconsistent with the county's actions here are inconsistent with the special law that the legislature imposed on it.
You've read these briefs just like I have. You know, there's a huge argument whether sovereign immunity applies to a general act or a special act.
No, that's not really the issue. And that's, the county has conflated the issue of the applicability of sovereign immunity, which is a different question of waiver. We don't assert that you know, special act can waive sovereign immunity. But if you look at, you know, some of the cases that we cited, particularly Bill Stroop Roofing and Palm Beach County versus Town of Palm Beach. In both of those situations, the courts found sovereign immunity not applicable because the county was trying to impose an obligation that was inconsistent or avoid an obligation that was
But
inconsistent.
those were general act cases, weren't
They were general act cases, but I would say to you, Your Honor, the county has not cited a single case to us to say that the county is excused from abiding by the requirements of a special act. Otherwise, with the special act, the county, anytime it chose to do so, could say, you know, we don't really like the obligation that the special act is imposing on us, so we're going to assert sovereign immunity for the legislature's will.
I mean, doesn't this statute address that in a very cryptic way?
I'm not sure.
The statute that I just read to you, doesn't that address that issue in a very cryptic way, that they have the power to carry on county government to the extent not inconsistent with general or special law?
Well, I would say that it's absolutely inconsistent with the special.
Do you think if the legislature felt there was a dichotomy, they would have said inconsistent with general law only?
I mean, I think that, maybe I'm misunderstanding your point, but I believe that this.
You won't be the first one.
No, the county's actions here are clearly inconsistent with the requirements of the special act, so it doesn't give the county the authority to avoid that. I mean, I'm sorry, go ahead, Your Honor.
Let me ask you this is what the distinction you're drawing. So under the Constitution, the legislature can waive sovereign immunity by general law. But you're saying that that's a distinction between the issue of whether sovereign immunity applies in the first place. And so, in other words, the general law concept only applies in the context of waiver. Am I correct?
That is my position.
So your concept is it doesn't matter if these cases, Stroop, that's, I'm saying that correctly.
Stroop, yeah.
Yeah, it makes no difference that the mandate, the legislative mandate that brought that case outside the ambit of sovereign immunity was derived from general, special law.
Correct.
Because the special versus general law distinction only applies in the context of a waiver of sovereign immunity that's already been established.
It's exactly our
So
position.
could you talk more about, but do you have any cases in which this concept, this clear legislative mandate concept, for lack of a better phraseology, has been applied in a scenario in which the duty to which sovereign immunity doesn't apply derived from special law?
not from a special law, but the county can't
You
point.
think that's just incidental, that's just happenstance? You know?
Well, I mean, we do have the case. I mean, I think that although the court didn't use the word sovereign immunity, by determining that the county's obligations as a charter county, the county argued before the Supreme Court that it should not have to pay, that the mandatory payment obligation in the special act shouldn't apply to them because they're a charter county. They argued that their budget authority under
But it's very different argument than sovereign immunity. Sovereign immunity is you can't sue the sovereign.
Right, but the sovereign is the state. And so essentially here, the state has told the county, the county is the sovereign. The state is the sovereign. The county's sovereign immunity only flows from what the state affords it. And here the state has spoken. The state has said, we're enacting a requirement that you pay for indigent care. The county, for years and years and years, accepted that obligation. They recognized as late as the 2000s, in the late 90s and the 2000s, two different county attorneys and a county administrator recognized the obligations of the special act, finding that it could only be repealed. The only way to avoid it was to repeal it. They were looking at how to avoid it in the context of another ordinance, a county ordinance in 1972. And so, I mean, the county knew that this obligation was on it. It was only after the Supreme Court ruled years into this litigation that they belatedly raised the argument that sovereign immunity exempted them from the payment obligation.
Yeah, there's a Stroop to me, reading the briefs, seems to be the best case to illustrate your argument that sovereign immunity doesn't apply in the first instance. You can correct me if I'm wrong, if you like.
No,
better. So, but in Stroop, in the cases that cited, I think federal case, I think the parties discussed it, they characterized the holding of Stroop in a manner that could be analogized to this case, or could probably be distinguished, but that is that you can read this Stroop narrowly, or you can read it broadly. Narrowly read is that sovereign immunity can't be asserted against a claim brought by an entity or an individual who is seeking disgorgement, essentially, of funds, fees imposed in violation of a mandate against such fees, a prohibition on such fees. Is that here? But here it's a little bit different. Here, the plaintiff in this case is seeking payment in the first instance, meaning they're seeking payment, not disgorging funds that they were required to be paid by virtue of a fee or a tax imposed in segregation law, but they're saying, you have a duty to give me money. Is that a distinction without a difference?
Yeah, I think it is. It's just the opposite side of the same coin. I mean, the principle is still the same. There was in Stroop, there was a mandatory obligation, or there was a law that precluded the fee that was charged. Here, there's a law that requires the county to do something. I mean, I think it's astounding that the county can be here suggesting that the special law has no meaning. I don't know what meaning the special law would have. The very provision we challenged is the reimbursement provision in the special act. That's what this case is about. The county's saying, well, even though the Supreme Court upheld it, sovereign immunity gives us the opportunity to avoid it.
I mean, doesn't sovereign immunity really go to protecting the sovereign from liability? And in this case, liability was imposed by the legislature on the county. And the hospitals, as basically third-party beneficiaries of this, merely perform the work and submit an invoice. Isn't that really what this is about?
Well, I think that what it's about is a valid statutory mandate on the county. I mean, the Supreme Court's opinion would be meaningless if the county. They did. They acknowledge that there is an obligation. They're just saying now that the obligation is excused because of sovereign immunity. And I just don't see how this possibly could be a case where sovereign immunity is applicable. As late as this year, in Freed versus State, the Supreme Court affirmed the state's supremacy over counties and explained that counties are creatures of the state without any independent sovereignty, and counties can't frustrate the ability of the legislature to set policy. I I mean, the legislature even has the policy to abolish a county. So here, the legislature's imposed a payment obligation for the county to take care of its indigent residents. And that benefits not only the county, it benefits the indigent residents. The indigent residents will have a payment obligation for the care that they receive at the hospitals if this act is not upheld. And requiring the county, I mean, I find it, incredible that the county's been able to evade this obligation for so many years after the Supreme Court's rule. And I think that they've raised this issue of waiver, which really only comes into place, as we've talked about, if sovereign immunity isn't applicable. But we do believe that we have established, if the court wants to go there, the issues that the fact that an express unilateral contract was formed, through offer, acceptance, and consideration, and that we, in our briefs, we briefed this extensively. I'm happy to go. I don't know how much time I have left.
You're right on it.
Okay, so we do believe that, we have established, and I also want to point out that the evidence in the case was undisputed. There is no disputed issues here. You can take the trial court's order. It's a trial court's conclusions that were reached here that we're asking this court to overturn and recognize the validity of what the legislature's done. Thank you.
You're right.
Okay, thank you.
You have time.
Thank you.
Good morning. May it please the court, I'm Tom Elliott here with my partner, Amy Ferrier, and our co-counsel.
You've seen in your briefing, you've tried to confine us to the issue about whether or not there was a waiver by virtue of an express contract. The effort is that our opinion, which denied the writ of prohibition, Sarasota County Public Hospital District versus Venice, you seem to sort of interpret that to say, this is the issue we sent back to the trial court. I don't read it that way. So I just want to make sure, I don't read it that way. So I want to make sure I told you that.
Okay, well,
so if you want to try to persuade me otherwise,
well,
I'll give you a chance.
I mean, it is heavily, once we get past the procedural, jurisdictional prohibition issues, it talks about whether there's a complete meaning of minds, whether there's a contract that waives sovereign immunity. They say, the opinion says, this is a local law, which the Supreme Court agrees with. It's a special act, it's not a general law. So, and there are only two ways to waive sovereign immunity. One is by a general law, which this is not. And every case they rely on,
Again, the effort here is to direct us from the main issue. And the main issue, does sovereign immunity apply, period? Does it apply in this case? Whether or not it's been waived is a secondary issue.
Oh.
And it seems that your effort has been to focus us on the secondary issue, saying this is the only issue. I want to make sure you understand that I personally don't see it that way.
Okay, well, let's take a step back then. Sovereign immunity waiver basics, okay, because there is sovereign immunity for the county. I think we can all agree with that, okay? It is in the Constitution. It's not something that is granted by the legislature. That's not correct. It's in the Constitution. The Supreme Court opinion never mentions the word sovereign immunity.
But who imposed liability on the county? The legislature.
The legislature, through a special act.
Right. Nevertheless, they imposed the obligation. So sovereign immunity protects against liability.
Yes.
So the liability's been imposed by the legislature.
Yes.
You've argued that sovereign immunity protects the county from paying the hospitals.
Yes.
All the hospitals did is submit a bill pursuant to liability established by the legislature.
Your Honor.
So it's the legislature that you seem to have to argue that your county's protected from by sovereign immunity, and that makes no sense to me.
Well, Your Honor, that's exactly what happened in the Arnold v. Schubert case and the Hillsborough County v. Taylor case. Exactly what happened there. They say there are no cases with special acts. Those are exactly cases with special acts. In those cases, the act said if you buy this insurance, one of them actually they were basically variations. If you get more insurance than the sovereign immunity 768.28 tort cap, if you buy more insurance, you are subjected to the claims above the cap. That's essentially what those cases held, by special act, by special act. And the Supreme Court and then this court said, no, you can't do that. You cannot do it by special act. If they had done it,
So your argument is that the county is protected from liability imposed on them by the legislature
absolutely.
by sovereign immunity. So
In a special act, John, in a special act.
Well,
Not by general
what the
law.
act is. I mean, it's an interesting argument that you're saying an inferior sovereign is protected from a superior sovereign imposing liability on them by sovereign immunity. And the very existence of counties, they draw their sovereignty from the legislature.
They draw their sovereign immunity from the Constitution. There's a constitutional provision.
I didn't use that word. You're now imposing a word that I didn't use. I said their sovereignty. The fact that they are a governmental entity, a sovereignty,
Yep.
they draw from the legislature. They serve at the will of the legislature. The legislature grants and denies their ability to exist.
I suppose you can look at it that way, but that doesn't mean the legislature can impose an obligation on them by special act, as opposed to special law, as opposed to a general law that applies to all the counties.
So the legislature is, so you think this is a nullity, that they shouldn't, legislature shouldn't even impose this obligation on them?
Not. In fact, actually, Your Honor, that's a good segue into, we were talking about chapter 129, and we probably didn't make as much an issue with this in the brief as we should have, but 129.07, Your Honor, taking you to a little bit later, says that if there's a contract that's not budgeted for, it is null and
Well,
void.
that argument you asserted in relation to whether there is a
There's a
contract.
contract, right, which,
Which again is one step downstream from what Judge Morse is asking, but I wouldn't mind addressing it, because that, to the degree you're talking about waiver and the opponent's argument that is waived by expression of the contract, that argument might be asserted successfully in response to a breach of contract action, but because that argument, if I recall correctly, that statute talks about the indebtedness in null and void, not the contract for the indebtedness. So it doesn't undermine the existence of a contract for the purpose of determining whether there was an express written contract that waived sovereign immunity. So you could actually argue all day long successfully that, hey, we don't have to pay because this wasn't budgeted and the indebtedness is null and void and it's unenforceable. But that doesn't eliminate the fact that there was a contract for the indebtedness.
if we don't have to pay it because it's null and void, we get to the same place.
No, I don't think you get to the same place because, no, you certainly don't, because the defense of sovereign, the argument against the defense of sovereign immunity, with regard to waiver has to do with whether it was waived by express written contract. So a county that's a sovereign can enter into all kinds of contracts and say, yeah, sure, we waive sovereign immunity by entering into this contract. And then there could be separate questions about the enforceability. You could have all kinds of defenses to the enforcement of that contract. It doesn't mean the contract didn't exist in the first place.
And they in fact denied there was a contract for many years.
Well, that now.
Until they realized they have to get around sovereign. Okay, well, the law, again, the law is very clear that sovereign immunity, and I'm not sure I appreciate fully the concern, but the law is very clear that sovereign immunity can only be waived in two ways. The county has it, there's no question about that.
You're not sure you fully understand my concern? We can go to the text of the statute. The statute says that, that if you essentially contract over your budget, the indebtedness, is unenforceable. It doesn't say that there's no contract.
Well, it says you may not expend or enter into a contract, is how it starts, or enter into a contract, requiring expenditures in a fiscal year for more than the amount of appropriations each in the budget. And then later on, it says any indebtedness contracted for any purpose for either of these funds in exchange or in excess is null and void. So I think it does start with the contract, because it talks about.
Agree, disagree then. All right, go on.
Well, the concept that The concept that the county may be a subdivision of the state doesn't mean that the state gets to run roughshod over the county. That's what sovereign immunity is for. And it is recognized in the Constitution. And the Florida Supreme Court says there's only two ways you can waive it. In fact, for many years, there was only one way, and that was express waiver in a general law that was clear and unequivocal. And then with the Pan Am case that came in 1984, they said, okay, well, if you've entered into a contract, you can waive it that way too, which is how we got there, because there is no question this is a special law. We've cited half a dozen Florida Supreme Court cases that say you do not waive sovereign immunity by passing a special law that mandates that you do this or that, whether it mandates you pay a judgment, whether it mandates you pay a fee, whether it mandates you pay somebody that submits a bill. That is not waived by the state saying, we've got a special law here, you got to do this. The county doesn't have to do it. That's what sovereign immunity is. They don't have to do it.
May I ask you a question I should have asked you up front? Mr. Wallace is here representing the district. You speaking for him too?
I'm happy.
Well, I'll just say that we're aligned with the county.
Right,
I was,
but I didn't, if you wanted time.
oh, yes, my comment on that, and because I didn't have a chance to whisper it to Tom, is if you need all the time, you take it. I know you've asked a lot of questions. I have just a couple of limited points that can either happen in this argument or the next one. It doesn't matter.
Okay, that's fine. Okay, so you use all the time up to your 20. If you got something left, we'll let Mr. Wallace
enough.
have it. And if you don't, then we're going to hear from you in the second case.
Fair enough.
All right.
Thank you.
Thank you. And I was going, I had it in my mind to say when I finished the introductions, but then you kind of got me with a question right at the beginning, so it's all good. So anyway, yes, sovereign immunity, the county absolutely does not have to pay the extra amount that the bill in Arnold said, the extra amount that the Hillsborough County v. Taylor thing said. It doesn't have to pay this. That's what sovereign immunity is. It has that right. Okay, and the fact that if it was a general law and applied to everybody, and that's every case they cite, general law. They
The
cite
Arnold and Hillsborough County cases, were those about waiver, or were those about, about whether sovereign immunity applied in the first instance?
So Hillsborough County v. Taylor it said you can't, the trial court read the statute to require a payment, okay? And this court said, no, you cannot do that because there's sovereign immunity. And when it got to the Florida Supreme Court said, okay, we don't read the statute to require that payment anyway, okay? But this court held, no, you can't require the payment under the special act because the county has sovereign immunity. It is a direct, on-point sovereign immunity case.
We got reversed, right?
I'm sorry?
We got reversed, right?
No. You've got the
Which case are you talking about? Where we held this?
Hillsborough County v. Taylor.
Okay, I'm sorry.
I'm not, the earlier case in this had nothing to do with sovereign immunity. It had to do with home rule and, more to the point, the privileges. And sovereign immunity has been pled at the beginning. There was some comment about it when it was raised. It's on page 133 of this massive record, and page 268. Sovereign immunity is one of the defenses the county has pled from the very beginning. Now, they proceeded under the privilege thing because that's a pure question of law. As we thought from the opinion from 2021, sovereign immunity has factual questions, or can have factual questions. That's what Judge Lucas's opinion said. Look, you got to go back and decide his
Which
factual.
opinion you're saying says that? Is this?
2021 from this court.
You're talking about Hillsborough County,
No, I'm sorry.
was the 1988 case in which?
Yeah, we got a lot of cases.
Which it was reversed, but on different grounds. Hillsborough County, we being the second district was reversed, but on different grounds.
I don't think it was reversed. I think, well, the only thing what the Supreme Court did that's pertinent to this case, to this court's decision, is they said, okay, we hold that the way this trust fund was set up in the state legislation did not purport to waive sovereign immunity, okay? And this court said you couldn't waive the sovereign immunity. The Supreme Court says we don't read it as waiving sovereign immunity. So you get to the same
First
result.
cause of action in Hillsborough County.
It was-
The tort action brought against the.
Yes, because it was damages because of negligence, yes.
So, yeah, so that seems pretty straightforward, that there's sovereign immunity against the damages claim.
There is sovereign immunity against everything except a general law and a contract.
Except at least according to Stroop, a cause of action brought to disgorge a government who has imposed a fee or tax in derogation of state law.
State general law. State
Well,
general.
Again, you need to, I mean, we're all going around and we're all in doubt, but, the appellants are saying that that analysis, occurs before you get to waiver. In other words, it doesn't apply at all. And yes, of course it applies when you're suing in tort, suing the county hospital in tort, Hillsborough County.
Because 768.28 is a general law, just like the law in Stroop, just like the law in Sandford. General laws, they apply to every county.
Let me ask you this, the answer 76828 is a general law in which a limited waiver of sovereign immunity.
Yes.
What about, let me ask you this, in a mandamus action, why don't governments assert sovereign immunity all day, every day in a mandamus action? You sue the Secretary of State, you say, because in mandamus to, put someone on the ballot, or, I have sovereign immunity, I'm sovereign, you can't sue me, I'm a division of the state government. You can't sue me in mandamus. Why? Why isn't sovereign immunity a good defense to that?
I think because they're not seeking money, Your Honor. They're seeking a declaration that somebody gets to be on the ballot, for example. That's not a monetary relief. Their sovereign immunity.
Talk to me about the Supreme Court provision, excuse me, the constitutional provision that you say establishes sovereign immunity and confines it to money judgment. I mean, I'm not going to be speaking out of ignorance, maybe I forgot that. In other words, the mandamus actions to compel a ministerial duty, which happen, thousands of times a year all over the state against state and subdivisions of the state, to say, hey, there's a mandate, you have a ministerial duty imposed to you, and so, and presumably you can bring a mandamus action to compel a duty imposed by a special act, couldn't you? Could you? The ministerial duty, it's clear. You have a right to the writ.
And before we get too much farther into this, you've got 5 minutes left, so we want to probably shift to some other issues at some point. But go ahead and answer.
Let me just say, in Hillsborough County, this court said, since Article 10, Section 13 of the Florida Constitution prohibits waiver of sovereign immunity by the passage of a general law, except by the passage of a general law of the legislature, prohibits waiver of sovereign immunity, except by the passage of general law, any waiver of sovereign immunity or attempts to create sovereign immunity by special act would be null and void. No?
I'm asking you why sovereign immunity is not a good defense, why it doesn't happen all day, every day, when thousands of mandamus actions are brought against all these governments all across the state to compel a ministerial duty. Why isn't sovereign immunity a good defense to that? If, let's say that the duty derived from a special law, you can't get mandamus.
Your Honor, I haven't looked at the mandamus stuff in that context. I can tell you when they're seeking money like this, it is very clear, this court's written on it, or Supreme Court's written on it multiple times, it cannot be by special act. Cannot be, period.
Can't be that clear, because we spent all the time arguing about it, you all briefed it to death.
Your Honor, I think there's been a lot of obfuscation here. I think it's confusing. This, again, that's just basic. We've cited a half a dozen cases that say you could only waive sovereign immunity.
Let's talk about waiver. Okay, let's talk about waiver. Okay, in this case, or if there is sovereign immunity, it can be waived by a contract. So the way I look at this case very simply, you have the legislature imposing an obligation on the county. The county codifies that obligation basically in their code. The hospitals, in reliance on that obligation, treat indigent patients and submit a bill, and it's not paid. Why isn't that a contract?
Well, here are several problems with that, Your Honor. First off, and again, we come back to, you can't, the special act can't make the county do that. The county codification and the earlier opinion said, well, we're not just accepting this as ministerial. And that's part of what I think we're supposed to go back and have a trial on. How did this happen? The references you heard earlier to a couple guys from the county said, oh yeah, this is what it says in the 70s or whatever. They weren't asked about sovereign immunity. They were asked, what's the term of the thing say?
The county paid for a long time under this rubric.
No, it did not.
You say they never paid?
There may have been some payments in the 60s. I don't think anybody ever established that because this case is about the codification from 2000, whatever. They really haven't pursued the earlier ones, as I understand it. We may ever change a position here, but the codification and the testimony was undisputed on this, was no thought at all. They took every law that was out there, special act, ordinance, and everything, and put them together so you could find it.
I think you have
Less than one.
Okay. But that, so well, I'm going right to his point, Judge, so.
Okay.
Appellants are gonna reply. Why is the codification so important? I mean, couldn't the contractual offer, unilateral offer have occurred prior to the codification and just out there and dangling the unilateral offer? It's existed for decades.
I think the state special act can't be an offer for the county. It's not on behalf of the county. If you're talking about a contract.
Before the codification from the 2003 year, what didn't the codification is of the ordinance that already, I'm confused.
The codification,
Just so you know.
well, if I could finish the question.
Yeah.
Okay, the codification includes 2 ordinances by the county about how they're going to treat indigent pays. 2 ordinances. That expresses the county's true intent. It also codifies everything else.
So what are those 2 ordinances? Don't those 2 ordinances include the supposed promise to pay?
Under-
Shall pay?
No. They're discretionary, Your Honor. Those 2 ordinances are discretionary. They are different from the special act wording. That's a huge difference. That reflects the county's intent on what it wanted to do, and that's what the trial court found. It was not an intent to pay everything with no amount stated and so forth, with no contracted amount. So there is a huge difference in that. We've dealt with that in the brief, but I know I'm out of time, so I will. There's something else you want me to answer right now, otherwise I'll.
Yeah, you did brief that. So.
Yes. Thank you.
Thank you, I appreciate that. You have 5 minutes, sir.
Thank you. First, I wanted to start with Arnold versus Shumpert, because I know that's a case that the county relies very heavily on. And Arnold involved a special law determined to be unconstitutional, which raised sovereign immunity in the context of a tort action. And constitutionality and sovereign immunity go hand in hand. If the state goes outside its legal bounds and a law is determined to be unconstitutional, it might not be able to restrict the county's sovereign immunity in that situation. But here, we've got the situation where the county acted entirely, or the legislature acted entirely within its bounds. The Supreme Court's upheld a special law and imposed a mandatory obligation on the county. And so sovereign immunity isn't applicable in that. That case has nothing to do with what's happened here. And the county can't veto the state's action by invoking sovereign immunity. That would render a valid statute meaningless. What's clear from the county's argument is that its position is that if it chooses to assert its sovereign immunity to avoid a valid obligation, an obligation that the Supreme Court's upheld and that the legislature's imposed, it can do so because it's a special law. I mean, essentially, they're arguing that
Chapter 125, county governments wouldn't even exist, correct?
Correct,
That's
absolutely.
the only way they exist, by legislative authority. So any sovereign immunity they have flows directly from the legislature, correct?
Exactly, and the only provision in the Constitution that deals with bringing suit against, Article 10, suits against the state, provision may be made by general law for bringing suit against the state as to all liabilities now existing or thereafter originating. So, I mean, the county's argument, I mean, their only argument, and you can see their position is, they argued waiver. Their whole brief argued waiver. Their whole position in the trial related to waiver. They never addressed the issue of the applicability of sovereign immunity, and the judge didn't either in the trial court. They just focused on this issue of waiver. But as we've made, and the point we've made, and I think you've clearly understood, you don't get to waiver unless you determine that sovereign immunity.
Even if you do, the legislature imposed this obligation on the county. The county codified that obligation. The hospitals treated indigent patients in reliance on that, changed their position, sent a bill, didn't get paid. How is that not a contract?
I think it is a contract. I think we briefed that extensively, and we think that the evidence supports that. I mean, the county raised these purported justifications for not paying. They were saying that we didn't observe certain processes. None of those processes are in the special act. We did exactly what the special act requires. We provided care to more than 40,000 indigent patients over, more than a decade, for really well beyond a decade, and expect to be paid for that care. And not, as I mentioned earlier, not only does that benefit the county, it benefits the indigent residents of the county. The county wants to basically say it can disregard a policy set by the legislature if it chooses to do so. In the Freed case, as I mentioned, just this year, the Supreme Court reasserted the legislature's primacy over inferior local governments such as the county. And we believe this is absolutely a mandatory obligation. We're disappointed that it's taken us this long to get to this point, and we certainly hope the court affirms or reverses the trial court's decision and instructs it to approve the declaration that we've sought and mandate that the counties receive payment. So we do hope that the court issues an order with instructions to the lower court so that we're not back here again arguing over whether the county's trying to evade its obligation.
But could you, for the slow tip in class, we address the issue of the codification? I mean, I think, I might be misunderstanding what Joe was talking about, but the idea that the ordinance prior to and after codification are different.
I think that's a distinction without a difference. I mean, they first codified the ordinance in '63.
Right.
They then did it again at a later period, and then finally in 2000 they did it the third time. I see no distinction. I mean, the county began, as the court noted, and there was no dispute. The county did make payments under the local law at earlier dates. The county contended that after '72, the payments were made under another law, but that's meaningless. It doesn't matter. The county even made the argument that that special law expired, and laws don't expire. Those arguments were rejected by the Supreme Court, or those are established principles, and the Supreme Court rejected the argument that there was a payment obligation under 125 or 12709 as okay, thank you.
Very interesting case. You all did a great job with it. Your briefs and your arguments are very helpful to us. We're grateful for that. We're going to hear round two now, and maybe we'll pick up some different things or hear some things again that we hear differently.